Let me take the chance to congratulate you and your deputy upon your election to lead this committee and the members upon assuming this responsibility. Let me assure the Honorable Mulima Mayuni Abdallah Kiwanuka that on Thursday, 6th August 2026 at 10, I'm going to be here again together with the Attorney General to present written submissions on the state of human rights and freedoms, which I'm sure is the subject of Honorable Abdallah Kiwanuka's concern. So you can eat us fried, boiled, roasted, or even raw on that day. But today, we have come specifically to respond to your invitation about the concerns raised by the members of this honorable committee regarding the Uganda Human Rights Commission. Mr. Chairman, for weeks, concerns have been publicly raised regarding the administration of the Commission, including matters of its leadership, governance, conduct of meetings, handling of complaints, and the accountability of the leadership of the Commission for administrative decisions. I'm sure that is what prompted you to seek clarification from government. I appear today to respond to your invitation to explain the position of government regarding the recent developments affecting the Uganda Human Rights Commission. As government, we appreciate Parliament's continued oversight of constitutional institutions, and we welcome this opportunity to clarify the constitutional, legal, and institutional position regarding the matters that have arisen. As you have stated, government is aware that this committee has already engaged the chairperson and commissioners of the Uganda Human Rights Commission on these matters. We welcome these engagements because parliamentary oversight is an important constitutional accountability mechanism. I'm therefore addressing you on the assumption that you have already received information directly from those who are in charge of the Commission. My statement is only intended to clarify government's position, the ministry's constitutional role, and what we propose to do as a way forward. Our presentation is not about giving you information. You actually have all the information you need because the people in charge of the Commission have already addressed you. Mr. Chairman, because the Minister of Justice is stated to be the line minister, and the Ministry of Justice and Constitutional Affairs is the line ministry, there may understandably be an expectation that it exercises supervisory authority over day-to-day administration of the Commission. Mr. Chairman, this is not the constitutional position. The Minister of Justice does not exercise oversight or supervises the day-to-day administration of the Uganda Human Rights Commission. What we do is to coordinate government business relating to the Commission, and these are limited to policy, legislative matters, budgetary processes, but the internal administration of the Commission remains the responsibility of the Commission itself, acting through the structures that are established by law, Chapter 26. In reality, despite the expectations people may have, government cannot lawfully direct the Commission on how to perform its constitutional functions. In addition, government cannot interfere in its internal decision-making. That constitutional arrangement is deliberate. It was based on the decisions of the framers of our Constitution. The purpose was to insulate the Commission from executive direction in order to enable it discharge its mandate impartially. After all, as government, we are always the suspects before the Uganda Human Rights Commission. It is the government agencies that are often in the dock before the Uganda Human Rights Commission. Therefore, the framers of the Constitution were right to insulate the Commission from interference by the executive branch. In addition, we exercise restraint. And there's a difference between restraint and indifference. Let me allay anybody's fears that the minister or the Ministry of Justice is indifferent. We are not indifferent. We are merely restrained. Why are we restrained? We are restrained because the Constitution commands us to respect the institutional independence of the Commission. We see this, for instance, with the Bank of Uganda, where sometimes as the executive we complain about interest rates, but we must respect the independence of the central bank. Nevertheless, Mr. Chairman, the constitutional independence of the Uganda Human Rights Commission does not diminish government's responsibility to uphold, protect, and promote human rights, and to support the constitutional and legal framework within which the Commission operates. I therefore, on behalf of government, wish to reaffirm our unwavering commitment to the protection and promotion of the fundamental human rights and freedoms guaranteed under the Constitution. Human rights are not a matter of political convenience. They are constitutional guarantees which bind the state, its institutions, and every person exercising public authority. Under Article 20 of the Constitution, it is stated that our fundamental rights and freedoms are inherent, and they shall be respected, upheld, and promoted by all organs and agencies of the government. The Commission, therefore, is a very important institution. It was deliberate that the Constitution makes the Human Rights Commission an independent institution.
Point of procedure, Mr. Chairman.
To protect and promote human rights in Uganda.
Procedure, Honorable Nalukola.
Mr. Chairman, I believe it is procedurally right for me to make a humble request that the Minister allow us to share the written document is reading from so that we can be on the same page, if it is okay, Mr. Chairman.
Yeah, it's very okay, but when he came in, we had not made copies, and we thought he would lay our proceedings, so we allowed him to present, and then we shall keep a copy, we shall distribute to the members. Thank you.
Mr. Chairman, let me ask my assistant to ask my office to send a soft copy immediately to your clerk so that they can print. Yeah, my assistant is here. He will talk to you and a soft copy will be sent. In the Constitution, Article 51, members of the Commission are appointed by the President with the approval of Parliament. Their tenure, removal from office, and terms of service are also governed by the Constitution and the Uganda Human Rights Commission Act. The Constitution and the Uganda Human Rights Act safeguards the independence and legitimacy of the Commission. Article 54 expressly provides that subject to the Constitution, the Commission shall be independent and shall not, in the performance of its duties, be sub-independence, and we respect it. This independence, however, does not mean absence of accountability. The Constitution establishes a system in which independence is accompanied by constitutional, legal, and financial accountability. After all, the Uganda Human Rights Commission is a public institution. It is funded from public funds, and it is even required under Article 52 to submit annual reports to Parliament. Therefore, it is legitimate for Parliament and this committee, in the exercise of its constitutional mandate, to scrutinize the Commission's performance, the utilization of public resources, and compliance with the law. Independence does not mean you are above the law. Therefore, from the point of view of government, we wish to assert that independence and accountability are not mutually exclusive. They should actually coexist. They are complementary safeguards of constitutional governance. Mr. Chairman, I now want to talk about the status of concerns have been raised regarding the position of the chairperson following her communication expressing an intention to resign. As we understand it, Mr. Chairman and honorable members, the legal position is that an expression of an intention to resign does not by itself necessarily constitute the completion of the legal process by which an office bearer ceases to hold office. Public office is created, held, and vacated in accordance with the Constitution and the applicable law. Consequently, the legal effect of any communication regarding resignation or cessation of tenure of a holder of a constitutional office is determined by the constitutional and statutory framework. This matter of resignation of the chairperson of the Uganda Human Rights Commission is governed by law, not public commentary, media reports, or informal communications. The government, therefore, will continue to respect and adhere to the lawful procedures governing cessation of office and any decision taken by the appointing authority in accordance with the Constitution. Our position on this matter of the resignation of the chairperson is informed solely by the law. After all, we do not want to prejudice any individual. Until the constitutionally prescribed process governing cessation of tenure has been lawfully concluded, the holder of office continues to discharge the functions, responsibilities, and obligations of that office. Equally, once the appointing authority has made a determination in accordance with the Constitution and the applicable law, the government will respect and implement that decision. As usual, the appointing authority will consult us and we will give our advice, and the decision will be his. On the functionality and independent on reports about the internal functioning of the Commission. These reports have been about infrequent meetings, cliques, decision-making processes that are not inclusive, but more importantly, how the Commission manages complaints. We are not so much concerned about this because of the emotions surrounding some of the dysfunctionalities in the commission. We are concerned because if the commission is dysfunctional, then it cannot discharge its mandate and it cannot serve Ugandans. Article 52 gives the commission a very broad mandate. The commission is supposed to investigate alleged violations of human rights. The commission is supposed to visit places of detention. The commission is supposed to undertake human rights education. The commission is supposed to monitor Uganda's compliance with international human rights obligations. Above all, the commission is supposed to report to Parliament. The commission even has powers of a court under Article 53. And these significant constitutional powers have to be exercised collectively, lawfully, transparently, and in accordance to the principles of natural justice and law and due process. While the Constitution mandates the Commission and gives it the responsibility to carry out these functions, the Commission itself has got to be answerable for what is happening inside the Commission directly to the Parliament. We consider it, Mr. Chairman, to be inappropriate for government to preempt your own findings as the parliamentary committee. Equally, and that's why we are here, we cannot disregard credible concerns regarding the functioning of a constitutional institution. We therefore believe that we should allow the established accountability mechanisms to go on with their duties, determine the facts, and then you recommend corrective actions. Sometimes people have differences in administrative approach or governance. This should not interrupt the work of the Commission. The public continue to look at the Commission to protect their rights. We therefore expect adherence to the Constitution and other laws. We expect efficiency. So even while you are carrying out your oversight duties to scrutinize what is happening in the Commission has to continue working. Now, as government, the most important concerns are actually about the Commission's handling of complaints. These squabbles are easy to deal with, but to us, the most important complaints are where citizens are dissatisfied with the way their complaints are being handled. If a citizen approaches the Human Rights Commission alleging a violation of his or her rights, they are entitled to have that complaint handled fairly, impartially, and in accordance with the law. At the same time, the Commission is not required to treat every complaint as establishing a violation merely because a complaint has been lodged. To many people in our society, they think the moment there has been a complaint, that means the facts are correct. That is why the Commission is required to investigate and determine the truth of every complaint. Unfortunately, Mr. Chairman, in our country, it is enough to be accused. The moment you are accused, investigations are now dismissed. We believe that every complaint must be followed by investigations to determine the complaint, to gather evidence, and also understand the circumstances of the case. The Constitution expects that the Uganda Human Rights Commission will observe natural justice. In other words, before a government institution is judged to have violated human rights, that institution must also be given a fair hearing. That actually has rarely happened. If you look at the reports, most of the reports has adjudicative powers. Sometimes people are not satisfied with what the commission has decided. The right to appeal to the High Court is provided. We do believe that the processes should not be personal. They should be institutional. Many of the problems that we have faced in the Uganda Human Rights Commission have resulted from complainants singling out and tackling the chairperson of the commission personally instead of tackling the institution. We have seen that happening even in our courts, where a judge is singled out for public lambasting, the same way the chairperson of the commission sometimes is singled out. Imagine, Mr. Chairman, if you were attacked personally, yet you are discharging your duty as chairperson of a parliamentary committee. These are some of the hazards that the Uganda Human Rights Commission has been facing, and that in a way distracts it from its work. When complainants attack the person of the chairperson, instead of saying, we are dissatisfied with the commission, we are now heading to the High Court. After all, Mr. Chairman, Article 50 gives the right to any citizen. It is not that you must only get redress from the Uganda Human Rights Commission. You can actually get redress from the High Court directly. Sometimes the allegations that complaints have been dismissed, delayed, or determined without adequate institutional consideration. Unfortunately, in this blessed republic, these allegations of dismissal, delay, and inadequate institutional consideration are not subjected to proper examination. Instead, they are handled through political debate. Naturally, the issues then evaporate into thin air. We are conscious as government because behind every complaint lodged before the commission is a citizen, a human being. We call these cases, but actually these are not cases. These are citizens seeking protection or redress for an alleged violation of fundamental rights. Therefore, delays in determining complaints or uncertainty regarding institutional processes undermines public confidence in the Commission and may prejudice access to timely justice. It is therefore in the interests of both the complainants and those being accused before the Commission that complaints be handled expeditiously, fairly, and in accordance with the law. Later, we will state what our recommendation is. It is important when a person appears before the Commission, that person should be told the steps which are going to be taken and even the timelines, so that the Commission can say, we are going to give ourselves 1 month to investigate this, and after investigating independently, we shall then invite the persons you are accusing to face you before a tribunal constituted, and the timelines are stated. The way it is done in the courts will tell you, we are going to hear the case for the following number of days. You must submit written submissions by this time. Judgment will be by this date. That has not often happened with the Uganda Human Rights Commission. And therefore, citizens are right to complain because they apparently don't know what is happening. We do not want an institution that is supposed to protect human rights to be perceived like a witch doctor's shrine, which is shrouded in darkness. You don't know what is being mixed. You don't even know what concoctions are going to be given to you, and you have no timelines. There has